Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nani.
And I'm Jason Hamola.
And this is
It's No Accident. All right, so since the last time that we filmed this podcast, we asked our listeners, we asked folks on social media for some questions, some things that they wanted to hear about. And interestingly, we got some questions that sounded like questions that we get from potential clients. A lot of times, these are things that come up a lot. But one that stood out to me, we got a question that said, "I slipped at a convenience store in a puddle leaking from a faulty cooler. The owner is refusing to give me any video footage. What should I do?" Well, first of all, call us. That's the first thing that you should do. But if that person were to call, where would you start with answering that question?
Sure. Yeah, no, you're right. And this is something that comes up all the time because, there's cameras everywhere these days, obviously in stores and outside of stores and everywhere. And so everybody, anytime I feel like anybody has, whether it's a slip and fall in the store or any type of injury inside of any type of business, people always just assume like, oh, well, it's on video. Just go get the video, right? Like it'll be easy for you to prove this case. Just go get the video.
Right.
And the reality is, what we always typically explain to them is number one, initially, like right off the bat, before a lawsuit gets filed, there's no way that we can force the business owner to give up that video.
Sure.
Right. I mean, the first thing we'll do is send a letter to the business owner demanding that they preserve the video and they don't erase it or throw it away or re-record over it or whatever. And then we can ask them politely and nicely, hey, will you please give us a copy of the video? But almost 10 times out of 10 times or 9 out of 10 times, they're not giving up a copy of that video, right?
Especially if it has something on it that's good for our client.
Yeah, exactly. And so it's a matter of, really the only way you can get the video is to file a lawsuit. And then once you file a lawsuit, you can, request and discover. I mean, it's not technically a subpoena, but for lack of a better term, I mean, you basically can force them to give it up to you, right? Once you filed a lawsuit.
And that creates a whole nother set of arguments from the defense as to why they shouldn't have to give you the video until certain things happen, namely being able to take the deposition of our client.
Right.
So, from what I've seen, the better the information that's on the video for our client, the harder it's going to be to get it from the defendant. Mm-hmm. Funny enough, I've had cases where there's footage on the video that's very good for the defendant, and as soon as we call the defendant or send them our letter, you get a phone call from the adjuster immediately or the defense attorney immediately and says, hey, we don't have any, there's no liability here. What are you talking about? There's no liability. We got a video that shows that the water was only on the floor for 5 seconds before she fell. There's no way we could have had notice of it. Mm-hmm. And if that's the case, great. I mean, it's not great for the person that called us, but it's great to know that up front so we don't spend time and money and our client doesn't, start going to get, they're going to get medical treatment anyway. But, thinking that the medical treatment that they're getting is going to be paid by somebody right. When in reality, there's a video out there that completely destroys their case. Because in Florida, it's not enough to be able to show that you just slipped and fell on water right. in a store. You have to be able to show that the owner of the store or the person that owns the property, that they had noticed that there was water on the floor. Right. So if this is a situation where a kid drops a drink on the floor 5 seconds or 10 seconds before our client then comes around the corner where the drink is on the floor and slips, there's not going to be a case there. It's not a case. So the sooner we have that information from the defense attorney or the adjuster, the better it is for us to be able to explain to our client that they don't have a case and everybody can go their separate ways.
Right.
That's why when we have an initial decline in terms of not giving us the video, it piques our interest and right. We're like, well, there must be something on the video.
Right. Because otherwise, if it was bad for a client, they would show you right away, right?
Exactly.
Like you just said. So if they're not going to if they're holding back on it, then it makes it seem like, all right, well, there must be something there, right?
Right. And I would say, you kind of talked about this with regards to a preservation letter, mm-hmm. but one of the most important things you can do in a situation like this is to reach out to either reach out to an attorney immediately so they can send a preservation letter, or put something in writing to the property owner or somebody, a manager, and make sure that you can prove that you gave that letter to the manager asking them to preserve the video. Because under Florida law, there is absolutely no duty for the property owner to save a copy of a video unless it's been requested.
Right.
Because, I think the theory behind that is, anytime that something happens in a store, you don't necessarily, you don't want people going out and just, saving all of this video just to save it. And then, not doing it for no reason. So what Florida law says is, if there's a reasonable anticipation that there's going to be a claim,
Right.
then you have a duty to save the video. And the easiest way to debunk any argument that there was a reasonable anticipation that there was going to be a claim is to send a letter and say, we're going to make a claim against you.
Right. So save the
So
video.
save the video.
Exactly. 100%. Because like you said, it's the laws. If there's a reasonable anticipation that there's going to be a claim, you got to save it. And there's been courts that have basically determined that just the fact that the person got hurt isn't good enough.
It's not good enough.
Right. And so, like you said, it's a matter of putting it in writing. And like you said, if you hire an attorney, that's the first thing the attorney's going to do. If for some reason you're not hiring an attorney right away, the best thing to do be to do it yourself. And like you said, and keep whatever you got to send it to them in writing, and you got to keep a copy of it, whether it's an email or a letter or whatever, to be able to prove it later on. Like, I think I've had people before who like, well, I sent them a letter, and it's like, well, do you have a copy of it? No. And it's like, guess what? They don't either now, right? Magically.
Right.
Right? So, it's super important though. And, like you said, the theory behind it, I guess was, I agree with you somewhat, like, there'd be a burden on every company or every business to have to keep so much video for, unlimited periods of time. And I get that to some extent. I feel like these days it's not, I feel like those laws came around back when it was on like VHS.
Right.
These days it's not as burdensome because
especially if there's an incident report created.
Yeah.
Like if the person falls, goes to the trouble of seeking out a manager and actually goes through the process of creating an incident report, I think that the video there should be a duty that's created right at that point.
right.
If it's a situation where somebody falls in the store and they don't think that they're hurt, and then 10 days later just realizes that their back is hurting or
Yeah.
their ankle's hurting, and then goes back into the store, at that point, I think the duty is probably created then. But, if nobody in the store knows, then there shouldn't be a duty to just preserve every bit of video, in perpetuity on the IFCOM that somebody may have been hurt in your store.
Sure. No, I agree. And what you just said, it brings up another issue with this kind of a situation where, like you said, if you don't realize that moment, that day you're hurt, and you wait a week and then come back, most of the time these businesses have policies where they're basically deleting video, surveillance video recordings after sometimes maybe it's 24 hours, every week, every 30 days.
Yeah.
So if you wait too long, the stuff's gone. Even, maybe, it's not like they did it intentionally, like, oh, we're going to go delete this. It's just like, this is our policy. We delete it after so much time.
Yeah, they only have so much storage space on their server, so every 30 days, whatever was recorded 30 days before that starts getting recorded over. Every 14 days, it starts getting recorded over. And that's why it's so important to get a letter to them immediately.
Right.
If you're not going to hire an attorney, send something.
Exactly. And like you said, the proving the notice of it is, it's in a slip and fall case like this question's talking about, it's the hardest thing to prove that the store either, in this situation, we're talking about a leaky cooler, right? You got to basically prove that the store either knew that there was a leaky cooler and just didn't do anything about it, or that it had been going on for such a long amount of time that if they're paying attention, they should have known about it. And a lot of times having a video is, going to be the best way to prove, like, how else are you going to prove that? If you're just a customer coming through, like, how the heck are you going to know that?
Right.
And so, like you said, when it once we actually file a lawsuit and get to the point where we can get the video, one of the arguments is then they want to take our client's deposition before they give us the video, and we're saying, no, you got to give us the video first before you take the deposition. Another argument, though, is how much video do you get? Right?
Gosh, yes.
Like, they're going to try to give you just the 30 seconds that showed the actual fall, and whereas we're like, no, I want 24 hours or some days going back, so I can see, was this cooler leaking for days or not, and that's always a pretty big fight too, right?
Yeah, were there employees going out there cleaning this thing up constantly? Could you see the puddle of water leaking from the cooler in the 24 hours beforehand? All of that stuff. And, it's funny because, it's always the situation where as soon as you get over one hurdle, there's another hurdle to get over. There's another argument that gets made. All right, well, we'll give you the video, but we're only giving you the 30 seconds before and after she fell.
Right.
All right, well, now we have to have another fight as to how much of the video is going to be given to us. We have to go in front of the judge a lot of times, and they have to make that decision. And, our clients, we get asked a lot, and, sometimes our clients give us pushback because these cases are taking long. These are the sort of things that prolong a case. Every little issue gets litigated and a judge has to make a decision on every little issue. And you start adding up these little issues one after another. And, it's not the easiest thing to get hearing time. Leon County is a little bit easier than just like Miami-Dade or Orange County.
Yeah, or Tampa.
Or Tampa, or some of these counties that have bigger cities in them. But it's still not very easy to get hearing time around here in North Florida. So, add those things up over time, and it doesn't take long for the case to have drawn out for a year, 18 months, 24 months.
Oh yeah, easily. I mean, right, like one of those little issues, like you're saying, just in terms of like the fight over giving the video before the deposition or after the deposition, that could take easily 2 or 3 months, if not longer, just to figure that out, right? Like we file a motion, they file a response, we got to wait a month or so to get a hearing on it, and then even sometimes you go have the hearing, and a lot of times the judge will make a decision right then, but sometimes they don't.
Right.
Then sometimes you're waiting another month or two for the judge to make a decision.
Then they make the decision. Then you have to coordinate schedules with the defense attorney to get the deposition scheduled, and it adds up. It certainly adds up. One of the other things that, just real quickly, as far as proving the notice element to these cases, it's not what they ask, but it kind of dovetails with what we've been talking about. Talk to a manager. You fall at a store, talk to a manager, talk to an employee, talk to somebody after you fall, especially with a faulty cooler, or, you can see water coming out of the bottom of a cooler. A lot of times the manager or the employee is going to be a lot more open when you're just got up off the ground right after you fell than they will be in a deposition, 12 months down the line. And you're asking them, have you ever had any issues with this cooler before? Not that I know of, not that I remember. Whereas, 5 minutes after you fell and, they're helping you get up off the ground, they might say, man, we've had some issues with this cooler over the last couple of weeks.
Right.
And, we've been calling the company to come out and fix it, but they just haven't had a chance to get out here. And there should have been a warning sign there, but there wasn't. And so try to talk to an employee or a manager and try to get that information, because that's evidence that we can use to prove notice.
Yeah, and sometimes that's maybe in a case like that could be the most important evidence in the whole case.
Absolutely.
Really. Yeah.
This conversation continues and much more on the next episode of It's No Accident.